Now we are going to see about the appointment of directors of procedures. Section 152 deals with that. Section 152.1 subsection 1 says that the first director shall be the persons who have subscribed their name to the memorandum association. If somebody's name is there mentioned as a first director, they will be the first director. Otherwise, all the persons will be the first directors. They will be in office till the next annual general meeting. Every person elected as appointed as a director should have the director's identification number. They should give a declaration that they have not been disqualified from election from appointment as a director, should not have been disqualified. They should give a consent letter. The consent letter should be filed with the other appointment proceedings to the Register of Companies also. Subsection 6 says if the articles provides for appointment of directors every year, there is no provision, there is no need. Otherwise, 2/3 of the director should retire by rotation. 2/3 of the director board should retire by rotation. For example, if there are 9 directors, what is a 2/3? 2/3 is 6. That means every year 2 from this 6 group should retire. 2 1 year, next year 2, next year 2. So there will be continuity in the management. Somebody will be new, some old faces will also be there. For example, if a person is appointed in 2013, he will go in 2014. A person appointed in 2012 will go on 2015. Person appointed at 2013 will go in 2016. 2 persons will be going every year. New person will be coming and he will be there for 3 years. Then who has to go? The senior most person has to go. He has to retire. If there are 2 persons, the senior most person should retire. If there are persons, 2 persons appointed on the same day, who will be the senior? That can be decided by a lot, and that person can be asked to retire. That person will retire and a new person will. Next is the same persons can be reappointed also. Retiring person can be reappointed provided the general body meeting resolution is passed by the shareholders. Section 7 deals with in case if it is not passed, in case if he is not reappointed, what will happen? If nothing has done regarding the appointment, then the meeting stands postponed to the next week, same time, same place. If the vacancy of the retiring director is not so filled up and the meeting has not expressly resolved not to fill up, the meeting shall adjourn. The meeting shall adjourn to the next day, next week, same day, same place. If the meeting is on Wednesday, it is postponed to the next Wednesday, same time, same place. If that Wednesday is a holiday, then it will be postponed to the Thursday. And if this adjournment is only when the meeting resolves not to fill up the vacancy. In case in the next meeting there is no resolution is passed, then the person is deemed to be appointed unless they pass a resolution not to appoint that person. If it is put on the vote and he has lost, then also he cannot come. That is, a retiring person can be appointed provided a resolution is passed. If a resolution is lost, he cannot be appointed, and if nothing has been passed, it is adjourned to the next week, same day, same place. Next is regarding the appointment of additional director, alternate director, and nominee director, which is in section 161. Additional director. If the articles permits, the board of directors have power to appoint a person as a additional director. They will be in office till the next annual general meeting. The article should provide for that. Then only you can appoint a person as a additional director. Next is alternate director. Alternate director is a person who is appointed in place of another. For example, if a person goes to US, his son is there, he is going there for 6 months. In that case, somebody should be in his place. So a person will be appointed as alternate director by the board of directors. The period of vacancy should be more than 3 months. Then only they can. If he goes out of country for 3 months, then a person can be appointed. Then what is the duration? His duration of his directorship is that of the other person in whose place he has been posted. For example, A is a director, he has to retire on May 31st. Then the person who has been appointed in his place as an alternative director will be in office till 31st May. Once another person is appointed, this person's alternate post is vacated and he cannot act as a alternate director if another person is posted. He will hold office till the other person's tenure in the directorship. Next is nominee director. A person can be appointed as a nominee director. The articles should provide for that. The company law permits posting a person as a nominee director. Where the state government or central government may appoint somebody as a nominal director, or the person, financial institutions or investors may by an agreement place a person in the board as a nominee director. The board of directors can appoint them based on the agreement or by government act. They are the nominee directors. Next is a casual director. In case a person died during his period as a director, another 3 months is there for the next annual general meeting. For this vacancy, they need not call for the annual general meeting to elect a person. They can appoint a person as a director for the casual vacancies. Then section 162 regarding the voting. Voting should be done individually, not for collectively. If there are 2 directors are to be elected, they should conduct a voting for first director and then second director. For the post of first one, for the post of second one. They cannot pass one resolution with both, or they cannot go for voting collectively. It should be for the one person, one vote, like that. Then section 163 deals with the proportional voting. Unless otherwise provided, the company may provide for proportional voting for 2/3 of the directors. Why there is a proportional voting? Proportional voting, if it is not there, the majority people will elect all the people. For example, 5 vacancies, they are going for voting. There will be a person having a 60% share and another person having 40% share. All the directors, if they are going for individual voting, first person 60-40. Second person, he will also get 60% from this person. All the group of this 60% person having 60% voting will be elected. The person having 40% vote will not have any say in the management. For that, there is a provision for 2/3 of the directors may be elected by proportional voting system. What is a proportional voting system? Proportional voting system may be by simple transferable vote or cumulative vote. There are 2 options. One, if 5 people are to be elected, give a voting paper so that the 5 people can give a preference. I prefer this person as number 1, this person as number 2, this person as number 3 and 4, 5. This all the persons with the number 1 will be selected, and after that the 2 will be counted. Like that, there is a voting system according to their preference. Otherwise, another one, there are 2 vacancies, then everybody will be given 2 votes. They can give to the 2 persons, or they can do both the votes to 1 person. It is single transferable vote. For example, if there are 100 shareholders, 2 directors to be selected, all the 100 will be given 2 votes. Total value will be 200. All the 100 can give the 2 votes to 1 person. Then 1 person will be getting 200 votes. Other person will get nothing. Or 1 person will give 2 votes to 1 person. Another person may have a choice of giving one vote to another, one vote to another, like that. It is their choice. Everybody will, if there are two vacancies, all will be given two votes. They can give it to one person or they can give it to two different persons. This is regarding election of directors. In the next session we will see about a disqualification of the directors.